Well, I don't know if it means he will or won't prevail at the Supreme Court, but I did think it was a really important statement by Chief Justice Roberts. When Judge Boasberg ruled against the Trump administration on these deportations, Trump posted something on social media saying that this judge should be impeached. And Chief Justice Roberts, I think appropriately, as his job isn't just to lead the Supreme Court, he's also the head of the whole federal judiciary in the United States. So he's their leader. And he spoke out and said, for 200 plus years, it has been the tradition in this country that impeachment is used only, as the constitutional text says, for high crimes or misdemeanors. That's the basis for impeachment, not because you disagree with a judge's order. So I thought that was really important to try to quiet down some of that sentiment, and maybe to let members of the public, again, maybe they're Trump supporters, maybe they're Republicans who are not lawyers, recognize that this is not okay and this is not normal.
Welcome back to another episode of Just the Facts with me, Jill Wine-Banks, the Watergate Girl. Today, I'm not wearing my Just the Facts badge. I am wearing a Ukrainian pin in honor of the Ukrainian government and its position in the ongoing negotiations. I am very excited about today's episode. I can't wait to talk to my sister-in-law, Barb McQuade, from the hashtag Sisters-in-Law podcast. And she, as you all know, I know, was the U.S. Attorney in the Eastern District of Michigan, is now a professor at the University of Michigan Law School, and a MSNBC legal commentator, but she is also the author of a fantastic book, which you must all read. It is so relevant right now. It is Attack from Within, and it deals with how disinformation and misinformation are sabotaging America. And we're going to be talking about a lot of falsehoods because we want the facts to govern us. But we're going to also focus on Project 2025 and its impact on education particularly. So I can't wait to get to talk to Barbara about her expertise, both as a professor and the author of this wonderful book, talking to her today. Welcome, Barbara.
Thanks, Jill. I'm glad to be with you.
So let's get right to it. I want your opinion on a lot of things. We've already talked on Sisters-in-Law about a number of issues from Project 2025. And we did that before the election to warn our listeners about some of the dangers that were lurking in that document and some of the freedoms that we might lose if those things were actually implemented. And for me, the reality is worse than anything I expected. What do you think? Is it what you expected?
Well, I think I read that the Trump administration has achieved something like 41% of the objectives in Project 2025. So they are certainly making their way through it. And of course, Donald Trump kind of denounced it and said, I have nothing to do with that.
Right.
And then, he made his head of Office of Management and Budget, Russell Vought, the author of Project 2025, a prominent person in his administration. So I think I'm not surprised that they have been using this as a blueprint. But yeah, I am surprised by some of the things that we are seeing, because I expected, for example, a very aggressive program on immigration and deportation. Donald Trump ran on that. He won. And so I fully expected that. And we're seeing that. But what I didn't expect was for the president and his administration to exceed legal boundaries, which it appears they've done. I was doing national security cases during the Bush 43 administration, and they were very aggressive. They were putting prisoners in Guantanamo and trying out military tribunals and things that hadn't been used in hundreds of years. But they were always legally justified. They had maybe an aggressive but lawful reading of statutes in the Constitution. And when they crossed the line and a court told them to stop, they stopped. They obeyed that. And of course, now what we're seeing in the immigration arena is this use of the Alien Enemy Act, which is supposed to only be used during wartime or times of invasion. A
country. Let me just say, it's by a country, not by a gang.
Right, by a foreign nation state, not a violent gang. And that it certainly affords people due process rights. If you are in the territorial jurisdiction of the United States, you're entitled to constitutional protections. including due process rights. And so that would mean you get a hearing to make sure you are indeed a member of this gang and a non-citizen. So, what if somebody got scooped up in this who's a U.S. citizen? Well, who knows? We don't know. So I am surprised at, in the first administration of Donald Trump, we had some important checks on him, people who are certainly conservative and Republicans, but who cared about the rule of law and our institutions. And I think we're an important check on Donald Trump. This time around, it seems like those people are all gone. And instead, we have got people who are, just sort of pushing the agenda regardless of legal boundaries. And that is what I find so concerning.
It is. I agree with you completely. It is the absence of any evidence or any process for presenting evidence to show, in this case, that someone is a member of a gang, that someone is not a lawful permanent resident. So it's really terrible. But, because you're a professor at a university, at a law school, I want to talk about some of the things in Project 2025 that may impact your university, your students, you personally. And I worry about some of that because if we don't have a proper education and free expression under the First Amendment, then we're in serious problems. So let's focus a little bit for now, and we may get back to immigration because one of the First Amendment rights happens to do with Khalil, who was a lawful permanent resident, green card holder, married to an American citizen, 8 months pregnant. The marriage and the pregnancy are sort of tug on your heartstrings, but the important thing is he is a lawful permanent resident with due process rights. But let's start with some of the First Amendment issues, like his, for example, the protests that he led at Columbia, which are protected by the First Amendment. I've been on the board of the ACLU for a long time. I was, not currently. And, the ACLU protected the Nazis marching in Skokie, which is a heavily Jewish Holocaust survivor area.
I cited that case today.
Did you? Good girl. Okay. I grew up in Skokie, so it's my town, and I find them repulsive, but I also support their right to do what they did. I don't know if you know this detail, Barb, but they didn't actually end up marching in Skokie. They found that they had such opposition. They ended up marching in Chicago and only a few hundred people showed up. I mean, it was like nothing. It was a big nothing burger. But they did have the right. The ACLU defended their right to march, and that's the proper thing. But so right now you have Khalil being whipped out of New York to Louisiana as soon as a habeas was filed on his behalf. And as far as I know, hopefully he's still there. He hasn't been whisked to some other country. And of course, you have hundreds of people who were given to El Salvador, a country that, as far as we know, no one was from, that has a terrible human rights record. And they were taken out. I forgot what that bent position is called. Maybe you know it. They were taken out in a painful position from the plane and are now being housed at our expense. We're paying for them to be housed in a jail in El Salvador, where they have no connection. So what do you think in terms of First Amendment rights for, let's start with Khalil, and maybe even the doctor who is on the faculty at a hospital at Brown? She's a kidney specialist and is here on a special visa for her expertise and flew back to America and was whisked away. What's going on there?
Well, we'll start with Mahmoud Khalil, recently completed his graduate studies at Columbia and was a very visible and vocal part of the protests at Columbia University in support of the Palestinians in the war between Gaza and Israel. Now, he said some things that I think many people could find quite repugnant about Israel and Zionism and other kinds of things, but sort of in the same way you talk about, the Nazis marching. The substance of what they say is very different from somebody's right to say it. So it seems that he became a bit of a target because of what he was protesting about. But as you say, he got arrested and put into removal proceedings based on a kind of obscure part of the Immigration and Naturalization Act that says the Secretary of State may designate an individual for removal proceedings if there is a reasonable grounds to show that they could have substantial harm on the foreign policy of the United States. Because Mr. Khalil is a lawful permanent resident, that is a green card holder, he is considered a U.S. person. And so he is entitled to due process rights before he can be removed under this designation. So the fact that he was, arrested and then immediately sent to Louisiana, which, strikes me as an effort at some forum shopping there, where they might get some friendlier judges who are more hostile to immigration to rule on this. But the judge pretty quickly, a habeas petition was filed for him. That is a petition that someone is being held in violation of the Constitution.
It means present the body.
Yeah, that there was a hearing held saying that more hearings should be held before this will go forward. And I think that ultimately he will get due process, which is, did the agency make a reasonable determination in determining that he should be excluded from this? It may very well be, at the end of the day, he is excludable. The president and the executive branch have a lot of authority under the law for immigration law to protect our nation's borders. But it really feels like the reason he was selected was not so much for what effect he might have on our foreign policy, but on his First Amendment rights. So that's an issue that can be raised at a hearing. Now, of course, First Amendment rights are not absolute. We often think of them as, Congress shall make no law that you violated my First Amendment rights, I win. What it requires is what's called strict scrutiny. That is, the government has to show a compelling governmental interest and that their action is narrowly tailored to achieve that interest. So if they can do that, then they may yet be able to remove him from the United States. The fact that he has this green card, I think, is going to make it harder. But he, at the very least, is entitled to due process.
I would say there are some factual errors that we should point out to the listeners, because he was originally, they said, we're taking away because of your student visa.
Yeah.
Unaware that he had a permanent green card, making him a permanent lawful resident, and then went, oops, okay, well, we're going to withdraw that too, which means they really were ill-informed and did this, again, as you said, it was based on his First Amendment speech, not on anything else he did. And there's no evidence that I am aware of that says that he committed a crime at all. He was here lawfully.
Yeah.
He committed no crime. So it is a First Amendment issue. Another First Amendment issue unrelated to immigration is the curriculum issues that have been raised by the Department of Justice, particularly the U.S. Attorney for the District of Columbia, the interim U.S. Attorney for the District of Columbia, who has notified Georgetown Law School that it will not hire any of their graduates or their students for summer internships if the curriculum isn't changed and all DEI programs abolished. And I'm just wondering if you, as a professor, are worried about them interfering with the curriculum that you have selected to teach your students. And, where are we? The dean of Georgetown wrote a brilliant response basically saying, I'm sure you're aware that this violates the First Amendment, and I'm sure that you are going to rethink this and will fully embrace hiring our graduates and our students. It was a very well written that it interfered with their right, particularly as a Jesuit Catholic institution. But the same would be true of even a public university like yours. And I just wonder if, if you're teaching constitutional law and talking about masterpiece cake, is that, you're going to have to talk about gay rights. What is going to go on? How are you going to handle this? Are you going to obey, going back to your book, Barb, which of course we've mentioned many times, are you going to obey in advance, which is part of what dictators make people do?
Yeah, so I don't speak for my university. Universities, I think, are trying to figure out how best to respond to all of these things. But the idea that a prosecutor can tell a university what it may and may not teach is a violation of the First Amendment. I mean, the letter written by the dean of Georgetown Law School, as you say, was really brilliant because he pointed out that universities get to decide under the First Amendment what they're going to advocate for, what they're going to speak about, the right for people to assemble with whomever they want to be with. Those are all First Amendment protected rights. And so I don't think they can do any of those kinds of things. The one thing that seems more troubling to me is these directives that if you want federal funds, you must agree to abide by our conditions. Now, I still think that, of course, a university can't discriminate against people on the basis of race or religion or gender or any of those other kinds of things. But simply teaching about diversity and equity and inclusion, or teaching about race, or teaching about gay rights, I don't think that in any way is violating this, discrimination laws. And so I think there is an effort here to use disinformation to suggest to the public that the letters DEI mean illegal discrimination. And in fact, it's very far from the case. For example, when I'm teaching a class on self-defense, one of the cases we look at is the Bernard Goetz subway case. You probably remember this case,
of course.
Jill, don't you?
Yes, I do.
White subway rider ends up shooting 4 Black teens because he believes when they approach him that they're going to kill him. And he acts irrationally and he shoots them. And it's all about whether it's his subjective intent or an objective intent that applies there. And you have to discuss race in discussing that standard, right? I mean, about what that legal standard is. And so I don't think that any government directive can tell a university, you can't have that conversation in the classroom. Now, what I think they could do is to say, we have racial quotas, we accept this many kids of this race and that many kids of the other race, et cetera. But instead, what we've done here at the University of Michigan, and again, I don't speak for my school, but we've had state law prohibiting discrimination in higher education for decades. And so, some of the things we do is, inclusion means, and diversity means recruiting heavily in rural areas, recruiting veterans, making sure that people who are first generation law students understand that just because they don't have someone in their family who is a lawyer, that there are support systems for them to learn about the things that they might need to know in class. That's what diversity, equity, and inclusion means in a law school setting.
I just read that Harvard is now offering free tuition to students whose families earn, I think it's less than $200,000 a year. Do you think that'll get challenged?
So it's interesting, isn't it, Jill? Because that is a diversity, equity, and inclusion program. The goal is to make college more affordable to people who do not have the financial means to enter. So I don't know. I mean, it's not race-based, although my guess is it will have a disproportionate effect on people of color, right? It will be more helpful to people of color than others. So perhaps, there will be a disparate impact challenge of this, that it's inappropriately helping people of lesser means. But I think that's what inclusion is all about. And it seems to me that should be permissible under the law. But perhaps we'll see a challenge even to that.
I actually think that's what America is all about, and that it is one of the values of our country. And so it really disturbs me that this is being attacked. And I'm also surprised at the detail and the level of pettiness that the government has gone into in terms of what they are defining as punishable. And there are a lot of those. I mean, you mentioned grants. Medical research at Northwestern here in Chicago is being severely restricted. Columbia lost a lot of funding. I don't know, has Michigan lost funding because of anything that they've done to anger the Trump administration?
Not that I'm aware of, but they did end up on a list of 50 universities that are being investigated for allowing attacks on Jewish students during the Gaza protests. So we'll have to see how that shakes out. But, as one of our regents who himself is Jewish has said, the university is hard, if not harder than anybody, to make sure that everybody feels welcome here. Diversity, equity, and inclusion have been a big part of our mission for a long time.
It's scary to me that we have to think about these things. And there's a lot going on about in Project 2025 about education, many of which are totally irrelevant at the university level, but not completely. I mean, the abolition of the Department of Education will affect mostly grade schools and high schools. They're restricting or redirecting public funding from the schools to families so that they can pick where they want to send their children, educational choice, which means private schools and parochial schools. And I don't think that'll so much affect the university, but student loans being ended and for example, eliminating the public service loan forgiveness, that's going to affect your students, many of whom will enter public service and have spent years working toward the elimination of their student debt, and now that's being eliminated, which seems unfair once you've committed to that person that you will forgive their loan. What do you think the legal grounds are? What do you think the impact's going to be?
Well, first, it's important to remember that the Department of Education was created by an act of Congress. So for President Trump to say, I'm going to eliminate it or curtail it significantly like this, I think there's some limits to what he can do. So I imagine we will see some pushback about that he doesn't have the authority. Remember, the president's authority is to take care that the laws be faithfully executed. And so if Congress says, we want to have a Department of Education, and we're going to give you a bunch of money that's going to be used for student loans, and we're going to have a bunch of money that's used for special education and other kinds of programs, he can't really just say, now we're not doing that anymore. He does get to decide how to administer it, how to work through the details, the how of how all this will be executed, but not whether it gets executed. So I think we're going to see, as we've already seen in other areas, a number of lawsuits pushing back against all of these things. But, it may be only a matter of time, though, before the Republican-controlled Congress gets on board and pushes some of these things that he has been trying to do on his own and does give him the legislative cover he needs.
What about the firings of possibly some of your recent graduates or the withdrawal of job offers to people who are about to graduate in June? I know people who have lost internships and lost jobs. I know not just at the Department of Justice, which would be more likely to impact your students, but at EPA and at USAID, and are now unemployed. There's a husband and wife. Both of them lost their jobs, one at Justice, one at EPA. Are you seeing fear in your students or any concern? What are they doing to protect themselves?
Well, yeah, not just fear. We've seen students lose jobs. We had students who had been admitted into the DOJ Honors Program, which is a very prestigious, competitive position. It is the only exception where the Department of Justice hires people right out of law school with the idea that, here's some really talented superstars. We're going to hire them and train them. That's a really prestigious program, and those have all been removed, eliminated, gone. Same with students who had summer jobs lined up at the Department of Justice. They got canceled. And not only did they lose these jobs, but they lost opportunities to get other jobs.
Yes.
Because these jobs are all, accepted and offered in the fall. And so students who otherwise would have been in position for other highly competitive jobs didn't apply for those things because they got these great jobs at the Department of Justice. So they're scrambling a little bit to find, jobs, and not just any job, but jobs they're going to love. And so it's really unfortunate. But same, U.S. attorneys' offices are not offering internships this summer. I will tell you that when I was U.S. attorney, we used our internship program as a recruiting tool. We ended up hiring it later, after they graduated from law school and worked for a while. Some of our interns were some of our best hires because we'd had a chance to see them all summer. And they would say, I didn't know what a U.S. attorney was until I worked for the office for a summer and I fell in love with it. And so, a great way to attract the best and brightest. So it's a real harm to the talent that the department is going to be able to attract down the road, and just a crummy way to treat people.
I'm so glad you pointed out the unfairness to these good students who got these positions. And I don't think everybody realizes that you are hired when you graduate in the fall term. So by January, everybody has a job. If you then get your job withdrawn after inauguration, everybody who wanted to hire has already hired, and there are no jobs left. And also, remember, these are people who said, I want to enter public service.
Yeah.
And now they have nowhere to go in public service. It's really unfair and horrible. And I know that a lot of law firms have reached out to students saying, we'll hire you, but that's not a government job. And it's not the job you want. So it's really a shame. I hope that some of the not-for-profit organizations that are cause-related, that might be related to the Department of Justice, some of the Injustice Watch or the Innocence Project, in a way, it's different than being a prosecutor. It's the exact opposite, but it's at least a worthy cause, and I hope students will find their way into something. What about the loan forgiveness? I know someone who is in that position, was close to having the loan. I can't remember how many years you have to work to get your loan forgiven, but now is fired and won't be able to fulfill that requirement of a number of years working in the government. And again, that seems so unfair to me that they would now have a debt burden that they expected to be relieved of by working for much lower wages than they would have, where they would have been able to earn enough money to pay back the loan. Does that seem like the law should be allowed to fire you for no cause? Not obviously if you're fired because you did something immoral, illegal, or performed poorly, but if you just get fired because there's a mass layoff in order to hire loyalists, which is what I think this is all about, is that legally allowable?
I don't know. It depends on what the terms of the loan forgiveness were, I suppose, if they, entered into a contractual agreement for a certain amount of time. But usually it is, you get your loans forgiven if you perform this condition, which is you have to work in public service for whatever it is, 5 years. And if you do for each year of service, you will have your loans forgiven. If they're fired or their jobs are eliminated, they don't have the ability to do that anymore. Suddenly they've got this enormous debt they've got to pay back. So it's not fair. It's just another way that this effort of, in the name of cutting fraud, waste, and abuse, and there's been no evidence of any fraud, waste, or abuse. Instead, what's happening is we are seeing real people be harmed by this. Not only the students who are losing out on this loan forgiveness, but the people whose lives would be improved by having these people work in the federal government. We had at our U.S. Attorney's Office, we earned far more money than we spent through our collections with forfeitures and fines and other kinds of civil judgments and other kinds of things. And so for everybody you cut, you're costing taxpayers money.
Such an important point. Thank you for making that. Since we're mentioning law firms, let's talk about the problems they're encountering, because there have been some executive orders specifically attacking named law firms, and then a longer list of, I can't remember how many, 20 law firms. My law firm has been attacked, my former law firm, Jenner and Block, but Covington and Perkins Coie have been particularly targeted. One of them is fighting back and saying you can't do this. Let's start with, first of all, some of the things that they are being punished with are the withdrawal of security clearances, which means that they cannot represent certain defendants. It's a denial of that defendant's right to have them as their lawyer, because they can't look at classified documents if they don't have a security clearance. One is that they can't enter a federal building.
Yeah.
Federal buildings are public buildings. How can you stop someone? Yes, you can stop someone who's carrying a gun, but you can't stop a lawyer from entering a federal building, it seems to me. Not legally. That seems absurd. What do you think legally? Is there going to be a good outcome to a lawsuit challenging these limitations?
I think so. We've already seen Judge Beryl Howell enter a temporary restraining order, finding the executive order against Perkins Coie, just this one law firm that filed a challenge, to be unlawful. And there are a number of problems with it. One is their First Amendment rights to advocate, because it clearly is retaliation against the firm for representing Hillary Clinton.
Yes.
And so, if the government can punish them for choosing their clients and making certain arguments, that is a violation of the First Amendment. It's also not just free speech, but free assembly, which is free association. So imagine if you're at this law firm, you didn't even work on that case, and you yourself have lost your security clearance, government contract, and the ability to go into a federal building. And I think the other thing that is so outrageous about this, you mentioned about barring lawyers from this firm from going into a federal building. Federal buildings, there's where courthouses are.
Yes,
and
of
so
course.
if they need to go to court to argue a case, they can't go because this order says they can't. The other thing many lawyers do is when they represent a client, they go and take meetings at a U.S. Attorney's office or at the Department of Justice, and they advocate for the case to be not filed, or for the case to be dropped, or for there to be a deferred prosecution agreement or a plea agreement or whatever it is to review discovery. There are a lot of meetings that take place in government buildings. And so they effectively are not being able to practice their livelihood. And as you mentioned, denial of their clients the counsel of their choice, which is part of their Sixth Amendment right. So I think these orders are going to get pared back extensively. The one area where we are seeing some a series of questions, the EEOC sent letters this week to a number of law firms asking them very detailed questions about their DEI programs. Again, suggesting that this somehow is discriminatory under the 14th Amendment and under the Equal Employment Act, which prohibits discrimination in hiring. We'll see how that shakes out. My sense is most of it is using a wide net to recruit people. We go out to the National Bar Association, the preeminent African American Bar Association, and we recruit there to let people know who we are. I think those kinds of things in an effort to prove diversity should be just fine, but we'll see. And so that is one area where I think that they'll have to provide answers to questions before a decision can be made as to whether it violates the law.
Yeah, you mentioned the representation of Hillary Clinton causing Perkins Coie to be on the list. The representation of Jack Smith has caused another firm to, and the named one specific lawyer who represented Jack Smith was specifically named as being denied his security clearance, which means, of course, he can't represent Jack Smith without seeing classified documents. So, and that one gets into even the Sixth Amendment because that could be a criminal case. And a defendant has a right to the lawyer of his choice. And, in a civil case, it's maybe a little more complicated. But in a criminal case, it's clear that you have a right to a lawyer and to the lawyer of your choice. So it's the attacks on law firms for who they represent is causing them to lose clients. Because if you can't, as you were just noting, if I can't go into the federal building to try a case, then how can I represent a plaintiff or a defendant in a civil case? I can't practice law if I can't go into a courthouse.
Yeah.
That seems really, really bad. Let's talk about one other thing, or maybe a couple other just quick things. One is what I consider the rule of law and whether we're now in a constitutional crisis where Donald Trump and the Department of Justice are blatantly saying, we don't have to follow orders of the court. We can ignore them. And going to court and actually saying, well, that plane was not in American airspace. Point is, you, the defendant, are in American territory. You are within the jurisdiction of the court. You ordered the plane to fly away. You can order the plane to return. How could anybody go into court and with a straight face say that the president's powers under Article 2 are unchallengeable, that the Constitution gives him no judicial review of anything he does? I don't see any constitutional basis for making that argument. Is there something I'm missing?
No, I don't think so. The president certainly has a lot of power when it comes to the commander-in-chief clause. And there are some who, take this unitary executive view that the president has all of the executive power. But nonetheless, our system of government is a system of three co-equal branches of government, and it is the role of the courts to decide what the law is. So this idea that the president is relying on a federal statute written by Congress, the Alien Enemy Act, as you said, that contemplates use during times of war or invasion by a nation state. That has not happened. And so for a judge to make a ruling as to whether the Trump administration is correct in its application, that this law applies under current circumstances. That is an open legal question, and to me, a pretty bad argument from the Trump administration. I think one they're likely to lose. And so imagine the worst case scenario here. Number one, it's not lawful to invoke this provision right now because we're not at war or under invasion. So none of these people should be removed on this basis. Maybe there are other bases. Imagine if one of these men is not an unlawful immigrant, but is instead a U.S. citizen, or is not a member of this group. How did they determine who is and is not a member of this group? There's been reporting that it's simply based on whether they have certain tattoos that are aligned with this group. If that's the case, then is that, have they been afforded due process to ensure that we don't have the wrong people who are being deported in this instance? So that's where judicial review comes into play. If the president's right about all these things, then he gets to deport these people. But before that happens, we need a interpretation of the Alien Enemy Act, and we need due process to make sure that these people are who they say they are.
Let me just note that in terms of the tattoos, Hegseth got into some trouble because of his tattoo, but he had a chance to explain his tattoo. No one here has been given a chance to defend themselves or to explain themselves. We don't know whether they were any more accurate than they were in picking up Mahmoud Khalil because of his student visa, which wasn't why he's here. He's here on a permanent lawful resident green card. So unless you go to court, you don't know who's accurate and who isn't. Another issue is, part of your book, which is so wonderful and so timely right now, is how mis and disinformation is obeyed in advance. And I noticed myself editing myself I'm working on a children's book, and I talk about sex discrimination. And sometimes I use the word gender. I've deleted all words gender. If it was a major issue, I wouldn't have done it. But it was like, is there really a difference in what I'm talking about in terms of sex discrimination versus gender? No, there really isn't. And so why take on a potential challenge from some Mothers for Freedom or whatever they're called? Why bother? I might as well just say sex discrimination because that's an okay word. But I'm scared that people are going to start doing this obeying in advance, and that law firms, going back to this stuff about law firms, that they're not going to take on certain clients because they don't want to lose other clients. And how do we get around that? What's the answer?
Yeah, we're definitely already seeing this. And thank you for your kind words about my book. Back at you, because The Watergate Girl is also a great read. One of the things I cite in my book is some writings by Victor Klemperer. He was a German scholar who wrote about Nazi Germany and about how this concept really occurred in Nazi Germany, that people became fearful, like, I don't want to put a target on my back, and so I'm just going to keep my head down and keep quiet and hope they don't notice me. And that's very dangerous, because one of the things we rely on in our country to protect our democracy or to get anything done is public sentiment. And, Abraham Lincoln talked about this. Nancy Pelosi is fond of talking about this. With public sentiment, you can do anything. Without public sentiment, you can do nothing. And the way you gauge public sentiment is, are there protests? Are people writing about this thing? Are people sending letters? Are they speaking out? Are there op-eds talking about these things in the newspaper? That is how you measure public sentiment. And I worry that if people are doing what you described, this obey in advance, they haven't told me I can't say gender, but I'm just going to erase it myself so that I don't want any trouble here. Law firm, I'm not going to take on controversial clients because I don't want any trouble. I don't want to be the next one that is targeted for removal of security clearances and banning from federal buildings. But it's a really dangerous thing. And I get it. Nobody wants to be the one who's the lightning rod, keep your head down, get things done. But if you continue to do that and sort of cower and crouch, the bad things are going to happen anyway. And so the only way to stop them is through collective action, by getting people to speak out and point out to, ordinary citizens who may not have the legal training to understand just how different this is. I think it's why you and I do what we can to speak out from our small, little perches where we are to reach as many people as we can to help people understand when the rule of law is being broken so that people can, if they're outraged, they should be outraged and express that outrage.
I want to just say during Watergate, public sentiment led to outcomes that would not have happened.
Yeah.
There was also a fundamental belief by the criminal president then, Richard Nixon, that the rule of law existed and he obeyed the rule of law. He complied with court orders. But it was in part because he knew politically he could not withstand the public pressure that arose when people saw the evidence. Now, there was also a belief that facts were facts, and Democrats and Republicans accepted facts, which is not exactly what we're living through. But I think it's important to note that public pressure, so whether it's protesting, there are now a lot of protests, for example, at Tesla dealerships, that could have an impact. And a large, if, for example, Donald Trump doesn't obey a court order and has a clear and convincing, absolutely clear order and doesn't obey it, people may have to start shutting down the economy and doing something dramatic to show that we don't like that. We can't wait 2 years until an election to show that we don't approve. So it's a little bit scary that we're in this situation where we don't know what the Constitution is going to allow him to do. Someone today asked me, well, can't the Supreme Court change their immunity decision? And so the first thing I had to point out was, well, there'd have to be a criminal case brought against him that would raise the issue of whether, he had immunity from that criminal prosecution. And that's not going to happen right now. So that's not going to happen. But, something has to happen. I think, what did you think today when Chief Justice Roberts issued a thing saying you can't start yelling impeachment of judges you don't like their opinions of? Is that a clue that he's ready to maybe take on some of the issues that will get to the Supreme Court that we expect to get there right now as to whether he can do the things he's doing? Maybe that is a clue that he may not prevail at the Supreme Court, or am I reading too much into it?
Well, I don't know if it means he will or won't prevail at the Supreme Court, but I did think it was a really important statement by Chief Justice Roberts. When Judge Boasberg ruled against the Trump administration on these deportations, Trump posted something on social media saying that this judge should be impeached. And Chief Justice Roberts, I think appropriately, as his job isn't just to lead the Supreme Court. He's also the head of the whole federal judiciary in the United States. So he's their leader. And he spoke out and said, for 200 plus years, it has been the tradition in this country that impeachment is used only, as the constitutional text says, for high crimes or misdemeanors. That's the basis for impeachment, not because you disagree with a judge's order. So I thought that was really important to try to quiet down some of that sentiment and maybe to let members of the public, again, maybe they're Trump supporters, maybe they're Republicans who are not lawyers, recognize that this is not okay and this is not normal. I also think it does signal perhaps that Chief Justice Roberts is not, as some people think he is, like totally in the bag for Trump. I don't think he's totally in the bag for Trump. I think he has a worldview that in some ways is consistent with Trump's worldview. I think he has this strong view of a strong executive. And remember in that immunity decision where he said, we need a president who can be bold and fearless. Oh, God, have you met Donald Trump? And maybe at the time he did not anticipate that Trump would be reelected. But I think that he does believe that we should have a strong executive in the White House. But I don't think that means he's going to rule in favor of Donald Trump all the time. And in fact, he didn't in the first administration.
Right. And he didn't recently. He was part of a 5-4 decision that went the other way. So I think I agree with you. I took it as a very positive sign, a hopeful sign, not as definitive or predictive, but as the right thing to do. One last topic that is really bothering me a lot. I just came back from Washington and was reading about what happened at Arlington Cemetery. As you know, I worked in the Pentagon. I care a lot about this. All references at Arlington Cemetery to soldiers who were either Black, Hispanic, or female have been deleted. The Women's Memorial website was taken down. And I am beyond, I mean, again, I think it's petty that you would get into that kind of detail, but a Black Medal of Honor winner can no longer be featured. Is that something that someone can, maybe that the family of the Medal of Honor winner, who can challenge this? Who can say, you cannot do this? This is wrong.
Yeah, I don't know, because these are the kinds of things that where somebody is not sort of legally entitled to this sort of recognition, right? And so I don't know that anybody really has standing to challenge these kinds of decisions. That, I can remember walking through DOJ during Women's History Month, and there would be pictures of prominent women at the Justice Department there, people like Jill Wine Banks. And
people like Janet Reno and
all of them. And it's wonderful because it serves as inspiration for future generations and teaches current employees about the history of the department. But I don't know that Jill Wine Banks or Janet Reno or anybody has a legal right to have their story told. And so erasing their story, is probably not something where they have any legal recourse.
It seems to me it's so wrong. And the problem is that all of these things that are being unwound, including trying to unwind the pardons that President Biden issued, allegedly because of using an auto pen, which is, of course, routinely used, and where he verbally said, I'm doing this. He acknowledged what he was doing. They can't say, as they are saying, well, he didn't even know he did it.
Yeah, that's nonsense.
It's ridiculous. But it's going to be hard to unwind all of these things.
Oh, yeah.
It's going to take a lot of time and effort. First of all, it's hard to even keep track of the executive orders and the things that are being undone. And also, once some of the private information has been released, you can't put that genie back in the box. I mean, the information's out, too late. Nothing we can do. So I don't want to leave on an unhappy note or a discouraging note. I think that we are going to withstand this, that we will keep fighting, that we are in this, as Joyce would say, we are in this together. I thank you, my sister-in-law, for being here today and discussing these very serious threats that we face and that we will overcome, and that smart law firms and smart law schools are going to find ways around. They will follow the example of the dean of the Georgetown Law School and saying, this is a violation of the First Amendment. You can't do this. And that courts will, for the most part, uphold that. And that so far, Donald Trump is losing more than he's winning. And so we have to keep looking forward to him losing more.
Yeah, President Obama was fond of using the quote, sometimes attributed to Martin Luther King. I don't know who said it first, but the arc of the moral universe is long, but it bends toward justice. But I think that you have to add the caveat, but it doesn't bend by itself. And so all of us, no matter how small our contribution, need to do something to bend that arc of the moral universe toward justice.
Thank you, Barb. And thank you to all of our listeners who are going to go out there and protest and make sure that their members of Congress understand how they feel about what's going on, and show up at those town halls and let people know that you don't approve of what's going on. Thank you for listening, and join us again next week. Please rate us on YouTube to attract other listeners. We need to grow our audience. Thank you for listening to Just the Facts, where we talk about facts.